So, do you need a South Carolina personal injury lawyer? Well, you might not know the answer to that question yet, and that's fine. The point of this video is to give you a bit of information that you can use to determine whether you've been injured as a result of negligence, recklessness, or some other actionable conduct. And if so, what you can do moving forward to pursue compensation for your medical bills, your missed work, pain and suffering, and other damages you might have suffered. Let's start out by talking about some of the more common types of personal injury cases in South Carolina. First of all, you have automobile and 18-wheeler accidents. People get hit by cars and trucks all the time, and they get hurt really bad. So when the medical bills pile up and folks start missing work, they generally think about getting help from an attorney to avoid financial ruin. Another common type of accident is where someone gets hurt on another person's property or on a business property. These are usually thought of as premises liability cases. The most common types of premises liability cases usually involve people slipping and falling in a slippery substance or tripping and falling over an object. Other types of premises liability cases will involve criminal attacks on business properties that lack proper security measures, and these are called negligent security cases. You may also see a premises liability case that involves a structure collapsing or a fire breaking out on a property and injuring people. For example, back in 2019, a dock collapsed at a popular restaurant in Mount Pleasant near Charleston, and several people were hurt. This would be one of those situations where we ask whether the property owner took reasonable steps to ensure the safety of the people on the dock. The key in these types of cases is that property owners have a duty to keep visitors safe from unreasonably dangerous conditions in South Carolina. And if they don't and someone gets hurt, there may be a premises liability case there. Pedestrian accident cases are also very common in South Carolina, especially where there's a lot of people walking around on the streets. You'll see these accidents a lot in places like Charleston or Beaufort, Myrtle Beach, or downtown Columbia and Greenville. You'll also see a lot of people getting hit in these places while they're riding bikes or skateboards or scooters. In Hilton Head, for example, tourists ride all over the island on their bikes, and other tourists are driving around looking at their GPS because they don't have any idea where they're going, and it's a recipe for disaster. Other personal injury cases involve medical malpractice and dental malpractice. This is where a doctor or a dentist performs a procedure negligently or fails to diagnose a condition they should have diagnosed, and someone gets hurt or dies as a result. Medical malpractice and dental malpractice cases have some very unique statutory requirements. So although they're still negligence cases, they're much more complicated than your run-of-the-mill personal injury cases because the laws are designed to protect the doctors and cut down on lawsuits. The last thing we'll touch on is wrongful death. If someone gets injured due to negligence and they die because of their injuries, there's still a claim there. However, it's a little different because the person is no longer living and they can't bring the claim against the negligent person or business that hurt them. Instead, the personal representative of the deceased person's estate brings the claim, and that's called a wrongful death case. Now, let's talk about damages for a minute. When you bring a personal injury claim for damages, you're generally talking about two different types of damages. The first type is economic damages, and these are the tangible damages that are easy to quantify, and they usually have a receipt or an invoice, a dollar value on paper. Here, we're talking about things like medical bills, lost wages, and rehabilitation costs. We talked about economic damages. Now let's talk about non-economic damages for a minute. These are your intangible damages, and they're a lot more difficult to add up. Here, we're talking about things like emotional distress, mental anguish, pain and suffering, and loss of consortium for a spouse. These damages require digging in and analyzing how your injuries have affected your life or the life of your spouse. In other words, there's not a receipt with a number on it, so you have to do your best to come up with a value or hire an expert that can help you come up with a value. Now, we're not going to cover all the different types of damages in this video. There's just not enough time. But this gives you a general idea of what you're looking at in a personal injury case. The insurance company is going to look at the medical bills and lost wages, and they're going to do their best to ignore the non-economic damages. And usually, when we're fighting the insurance company over the value of a case, It's because they want to pay as little as possible, and the medical damages tend to form the baseline value of a case. Let's move on from damages and talk about negligence for a little bit. In any personal injury case based on carelessness or recklessness, or really anything other than an intentional act, you're going to need to be able to establish the 4 elements of negligence to get a successful outcome. And those elements are duty, breach, causation, and damages. So let's start with the first. To establish duty, you need to be able to show that the defendant owed you a duty of care, or a duty to act reasonably or refrain from acting negligently or recklessly. We generally owe a duty to those around us to act reasonably. For example, if we get out on public roads, we owe a duty to the other drivers on the road and pedestrians and bicyclists to exercise reasonable care to avoid causing those people harm. This is straightforward. However, this may be more of an issue where there's a case involving a trespasser or something like that. And then the question becomes, what duty do we owe to that trespasser, if anything? Now, we talked about duty, so let's move on to breach. We say someone breached their duty of care when they engaged in some sort of careless or reckless behavior. For example, if someone runs a red light or drives drunk, we can point to that behavior and say they breached their duty of care. They broke the law, so this is pretty straightforward. In the same way, if someone drives a jet ski too close to another boat to jump a wave and hits the people in that other boat, we look at that behavior and we ask whether it was reasonable. Clearly, it's not, so again, we'd say the jet skier breached their duty of care to the folks in the other boat. We talked about duty and breach. Now let's talk about causation. In any case of negligence in South Carolina, we have to be able to link the careless behavior of the defendant to the victim's injuries. Essentially, we're saying that the defendant did X, Y, and Z, and that resulted in the plaintiff getting injured. For example, we'd point to a drunk driver's behavior and say their actions, their drinking and driving, caused the crash that caused the plaintiff's injuries. Finally, let's talk about the last element of negligence, which is damages. Damages are a legal way of saying that you suffered harm. Here, we're talking about physical damages like broken bones, cuts, bruises, and other physical injuries, but we're also talking about psychological damages like emotional distress, pain, and suffering. The key here is that the person suffered some sort of cognizable damage. A person that isn't harmed, in other words, can't prove the 4th element of negligence. Now, it's important to clarify that the plaintiff, the person claiming damages, bears the burden of proof, meaning the plaintiff has to establish duty, breach, causation, and damages, and the plaintiff must prove all 4 elements. In other words, we need all 4 elements for a successful personal injury or wrongful death claim. Additionally, the burden of proof is by a preponderance of the evidence, which means more likely than not. And this is a much lower burden than beyond a reasonable doubt, which is the burden of proof in criminal cases. And if we just take a step back and look at this, it makes sense, because in a civil case, the only thing at stake is money, whereas in a criminal case, a person's rights and freedoms are at stake. So that burden should be a bit higher. Well, that's all I have for you today. If you have any questions at all, please don't hesitate to reach out to us. We're happy to give you a free legal consultation and talk with you about whatever happened to you. You can reach us at the number below in the video description, or you can find us at www.spetsasbuist.com. That's www.spetsasbuist.com. Thank you so much for watching this video, and we'll see you next time.